Okay, thank you, Supervisor. And I'd like to begin with a quick word of thanks, first of all, to the organizers for establishing this panel once again for the second year in a row, and also to dear participants that accepted our invitation to present. I expect really good topics. I have some insights into what are you going to speak about. For example, I heard that Jovan will propose something like a depassage in dealing with out of contractual obligations for torts in AI, while I will also address in my presentation a little bit of Dominica's writings on mandatory norms and really interesting perspective. So generally that would be my modest approach today. I will just have a quick remarks on the general aspects of the relationship between EU private international law and third states, and just give some customary remarks on subject. So this is the structure of my presentation. And yes, first of all, I would like to begin with a quick overview of the nature of the European private international law. So even before the European private international law, after the Amsterdam Treaty became exclusive competence of the EU institutions, we had Brussels Convention that set the stage for the cooperation between states in the civil and commercial matters, and from there on, it developed more thoroughly connected to the internal market principles and goals of the European Union. And as you can see, Article 81 ex Article 65 of the Treaty of the Functioning of the European Union set the really precise goal of the European private international law, and that is the uniformity of decisions. So it is considered that if courts of the member states would be able to give conflicting judgments on the same cause of action spanning across multiple jurisdictions in the EU, the certainty of the decisions and also rights of the parties concerned with the dispute could be infringed. And because there are higher principles of European law that mandate how the European private international law should be effectuated in its application, they have to be upheld in the process of interpretation, application of European private international law rules. So when we just look at the recitals, for example, of the main regulations like regulation of the Brussels 1 bis or new modern second generation regulations like EU succession regulation or matrimonial property regulations and maintenance regulation, we see that their rules are designed specifically to establish and achieve the proper functioning of the internal market. And what is the proper functioning of the internal market? Proper functioning of the internal market is area without internal frontiers, how it is spelled in Article 3.2. And area without internal frontiers requires that the persons and their businesses and everything that is happening within internal market be respected wherever it is litigated. So that's the area without internal frontiers. Decisional harmony, yes. But for example, I will, for that purpose, later on, I will use the split personality because I will present it from the European perspective and a little bit give it a criticism from the American point of view. And there is a reason for that. And before I further go, I will also mention that it is really important when we interpret European private international law to take into account Article 18. Precisely Article 18 to Article 21, which put the individual at the center of the internal market. So it's not anymore that the states has some, let's say, a priori rules predetermined with some connecting factors that they define what law will be applied to a particular relationship, but it is the individuals themselves who define what law will be applied to them. And member states have to respect their decision. And you see that some would say that that's the encroachment of the competence of the European Union, but it's not. Member states are allowed to still stay within the boundaries of their own competences when it comes to, for example, family matters or whatsoever. But at the same time, they have overarching primary law rules that has to be respected in relation to those persons. And for example, if some person duly or lawfully concluded, let's say, same-sex marriage abroad, that relationship has to be respected in other member states. So when it comes to that, just to finish up with a reflection, There is generally in private international law dogmatics differentiation between instrumentalist or deontological approach to adjudication. What does it mean? Instrumentalist approach to adjudication of cross-border disputes means that the primary conflict of law consideration is the impact that the decision will have on the general social good. So when courts decide what law will be applicable or whether they will take the case, they take that into consideration, and the rights of the instant parties to the dispute are of the secondary character. While in the deontological approach to adjudication, rights-based approach has really fundamental jurisprudential character, meaning that the rights of the parties has to be respected, and the even welfare of the society as a whole cannot override them. So that's the main basic premises. Of course, in their further consequential development, they differ, but that's the basis. And when it comes to that, we can say that also when it comes to jurisdiction, which is the primary question in private international law, whether the court may take the case and decide on the dispute, is regulated by the principles of mutual trust and mutual recognition. Mutual trust, in short, means that the member states' courts must imply that the other member state courts apply the European law properly, and they cannot review either their jurisdiction or their decisions on substance. They are obliged to respect it, and it's based on the principle of equality. So Luxembourgish courts believe that the Hungarian courts apply the Euro law properly, and that's it. They do not have a right to question that. Also, Jackson, also we will refer shortly after that, is a seminal judgment which decided that the member states' courts cannot allow jurisdiction in favor of the third state's courts based on their own national rules of jurisdiction. For example, the question was whether the forum non-convenience can be applied in favor of the third state's courts. They said no, if there is a jurisdiction that can be established based on the then Brussels one regulation, then the courts must respect it. And Turner-Govit defined that also anti-suit injunctions are not allowed in the internal market, meaning the member states' courts cannot preclude other courts who have equal competence to exercise jurisdiction from doing so, because that would infringe the equality of jurisdiction. Okay, and yes, requirements of the coherent choice of law assessment, we will go there. It's basically European private international law interest analysis. What is it based for? So we see that European private international law uses close connection also as the main escape and also as the main conflict of law consideration when designing connecting factors and choice of law rules, but it slightly differs from, let's say, significant relationship choice of law consideration that exists in American law. And what is the difference? Close connection is basically just geographical connection. So if there is a more interest in the applying law of the territory where the different elements, important elements of the dispute are situated, then the courts may apply, but it's still really restrictive. So courts do not have a right to extensively interpret close connection, because that would mean that they have unilateral right to define the scope of the European rules, and that would be problematic. While, for example, in America, it's really interesting. They have this concept of significant relationship. So if the dispute is more connected or more significantly have more significant relationship to another state, that state law may apply. But this also includes the balancing and weighting of different interests. We do not have that in Europe. In Europe, that's not allowed. Interests are only balanced in two stages. First stage is before the enactment of the specific conflict of law rules. And yes, in that regard, material law of the state that can potentially be applied is taken into account. The result is taken into account. And also in the process of characterization, whether certain disputes fall within the scope of one or the other choice of law rule, while the balancing of some specific other interests, let's say, are restricted in that regard. And it's left basically to the procedure of Article 257 of the preliminary rulings to CGU to decide whether certain bigger interests are at stake and how to decide it. So we can, of course, the question that comes by itself is what interests are at stake in conflict of law disputes. So we have on the one side domestic interests and European interests. Some argue that there is no such a thing as a European order public, but for example, we have Article 7 Rome 2, which defines that the party who are victim of the environmental tort may opt either for the place of the injury or for the place of the conduct, depending on which one is more favorable to the victim, and it's precisely designed like this in order to deter tortfeasor states or parties to establish their facilities near the border in order to avail themselves of the more beneficial rules of the place where the tort occurred. So if they didn't have the possibility to opt for the place of injury, then the tortfeasor would have incentive to manipulate the regulation. But it's not like that, and it's precisely defined like that in order to effectuate the principles of the Treaty on the Functioning of the European Union, Article, I believe, 191 or 192, which pursues the deterrence of the pollution in the Union as a whole. And similarly, we have specific treatment of consumers, employees, and insured. The same regarding applicable law and jurisdiction. They can sue their employers or producers or insurance companies, even in the place of their own residence. So they don't need to pursue action in the other courts. And it's basically just the effectuation of the EU primary law. And this Holbur case, really interesting, colleague Dominika discussed. There was an issue whether Bulgarian rule on torts may be applied to the traffic accident happening in Germany via these domestic mandatory rules through Article 16. And the court said effectively that, relying on the previous line of the case law, that the courts must first define, actually determine applicable law to the rules of Rome II, and then see on the next step whether there is a room for application of the mandatory rules. In my view, it seems fine, because in one regard it is considered jointly with the ordinary public rules. They do not differentiate on the European level that much between those two, because they can only happen after the rules of the regulation are respected. And one may ask, as an American, for example, why would a German insurance company's liability will be determined by Bulgarian rule just because the mandatory application of that rule may be required by national law? So that's the thing. We will always have in these problematic situations, whether we apply ordinary public or mandatory rules, conflict between European and domestic policies. And I believe that in most of the cases, there is no justification for the application of national rules, except there is extremely close connection to the case. But we can discuss whether in this particular case there was a connection that big to Bulgaria. And yes, recognition was used as some sort of substitute choice of law rules regarding names, comparison, and factual situation, effectively pursuing respect of the primary law rules on the choice of law level. And in that regard, the limitation of EU law towards third states has so many aspects, but primarily it's defined by internal and multilateral rule. When it comes to multilateral rule, the relationship is precisely defined through WTO and Hague Conference regimes. When the European Union became a member of the Hague Conference, it also adopted several of their conventions. For example, the most important one so far, Choice of Court Convention, and it will apply respectively to third states who are parties to the convention. In that regard, let's say the policies of the regime that are enacted by Hague Conference instruments will also be applicable between EU states and third states. But also, we should not forget the extraterritorial effect of EU law, and it exists in so many industries. For example, in these carbon adjustment mechanisms, AI Act, the GDPR, forced labor regulation that came into force, they all have rules that are specifically designed to tackle the activities that come from third states. So it's not anymore just that third states activity will be measured by the national rules, but it will also be measured by compliance with certain European standards that are required in order to pursue such activities on internal market. So it's let's say different approach than through the specific regulation that tackles the issue, but more indirect extraterritorial effect of EU law. Also, let's say that this Article 351 is really important in that regard. Supervisor and I had the opportunity to discuss it through one article, and we came to the conclusion that relying on case law and theory, that there are international obligations of member states and they have to be respected by this rule. But at the same time, if those international obligations conflict with European law, they has to be set aside and European law will prevail. It will be applied. So in that regard, when one thinks of it, it means that European law is bigger than international law when it comes to sources, at least in this respect. When international law obligations may affect the effectuation of this obligation may affect the scope of common European rules, they have to be set aside. So that's the main approach. And from that, of course, proceeds that EU has exclusive external competence in relation to third states, whether particular member states may conclude contracts or bilateral agreements with third states without the approval of European Union. It's debatable. It's a question. In this ERTA decision, in this opinion 130, court said that European Union has. It's the thing. Yeah. And yes, of course, although regulations of European private international law are mainly designed to navigate the issues within the internal market, they also have plenty of rules that are applicable also to connections to third states, whether to third state national, third state assets, or third state courts. The main regulation, Brussels 1 bis, actually prescribed that regarding third states, there has to be some exception, not common rules, harmonized European rules will be applied, but in lieu, it will be applied national rules. Those are the cases where the jurisdiction has to be established over non-EU defendants, except in limited amount of cases when it comes to producers, insurers, employers that I already mentioned, and of course, exclusive jurisdiction and choice of court under Article 25 Brussels 1 bis. When it comes to lis pendens, there is a difference between Brussels regime, because Brussels regime prescribes common rules in Article 33 and 34, but the courts will still avail to their own national rules because they must make this an Enquerungsprognose, meaning that they will apply their own national rules, and there is a possibility that the same Article 33 and 34 will be applied differently across internal markets, so there is actually no escape from availing to national rules when it comes to determination of these issues. And recognition and enforcement of judgments of decision is, of course, dealt with by national rules. And giving this quick general overview, now I proceed with specific details. I delimited in the chapters devoted to treatment of third state national, third state courts and judgments, and third state law. So there is a question whether the non-discrimination principle of Article 18, Article 21, Article 18 TFEU applies equally to third state nationals, and what is the requirement, whether they have to have some residence permit, lasting residence permit, whether they have to have some permanent activities within the internal market. And in that regard, case law of Bidar and Radia Hadi Ahmed effectively held that if the third state nationals may comply or have rights of the free movements on par with member states nationals, then the rule of Article 80 can be applied to them as well. Also, we do not have to forget, I mean, that's generally my approach. I hold the principle of the rule of law to have an equivalence effect. So the rule of law has to be applied equally to everyone. In my view, from the radiating effect of EU treaties, it follows that every citizen having any connection to the internal market has to be respected equally. So that's a question to discuss. Yes, also, generally when scholars speak of these issues, they always have in mind how to deal with third country defendants, as if the problem of the third country defendants is that big. I mean, if the third country nationals are residents in the EU, they fully, European law will fully apply on them. So, so it's that's it. I mean, if you happen to be in Hungary, me as a Serbian, I'm in Hungary. I pursue my activities here. I have my life here, my domicile here. I live here. Naturally, European rules will be applied to me. So why would my wife who lives, for example, in Kragujevac, also expect that the same rules will be applied to them? Maybe I can ask authorities for the derived residence for my wife based on the fact that I am having a residence permit in Hungary, but it didn't work out. It didn't work out. She had to apply by herself. She had to have a reason to be in European Union in Hungary, and then authorities allowed, and that's good. So if you want to be in European Union, okay. Oh, sorry. Okay, treatment of third state courts and the decisions. Mostly, I mentioned that treatment of third states law is also pretty okay. I mean, there is a universal application of law, whatever that law may be, whatever that law is designated by the connecting factor. No renvoi is applied except in the European Succession Regulation. Until I read Albert Armin Nierenzweig and other American scholars, I didn't know what's the meaning of renvoi. I thought renvoi just exists to ensure some international cooperation to respect third states courts, but actually I found out that renvoi exists only when we don't believe that much in the law that is designated but our connective factor, but we accept that it may turn out to our law. Yes, but for Americans, this process is unnecessary because they will always just apply Lex Fori rule. Renvoi is just a necessary additional step to the choice of law process. And when it comes to balancing of interest connected to third states law, we can say that there is, of course, differentiation compared to the balancing of interest of the laws of the member states. Of course, if foreign third state law infringes public policy of the member states have more scope of rights to determine that this law will not be applied compared to the situation where the other member states law is disputed. But yes, and in many cases, third states law is used as a datum of the rule of decision, meaning that it comes within the scope of the factual assessment of the lex causa. In cases with bilateral treaties, I developed this concept in one of the article also. When it comes to environmental disputes, I proposed the passage in situations when the conduct regulation rules of the tortfeasor party has to be taken into account, because Rome 2 does not allow that. Rome 2 for environmental damage determines one applicable law to govern the whole tort, both conduct regulation and loss allocation issues. While, for example, in some cases, under international law regimes, it is required that the due diligence of the tortfeasor actor is determined by application of their own conduct regulation rules. While Rome 2 does not allow such a depassage, but only allows that these conduct regulation rules be taken into account insofar as is necessary. But in most cases, that will fail, because it would not be fair to assess the liability of the tortfeasor actor who had to rely on conduct regulation rules enforced in their own state. So in that regard, general issues for discussions, I propose less concern over certainty of decision and more focus on the choice of law modeling for the individual case. For Americans, that was always quite understandable. Uniformity of decisions was some far goal, but not overriding goal of bill. And they don't believe that much that it's that much necessary, because they favor forum shopping, let's say, in that regard. Less a priori approach, more judicial discretion. Judicial discretion is generally allowed under the dogmatics of national private international law rules. For example, Ampasug exists, all sorts of general part of the private international law exists, but it's not enough to become a common approach of the member states, because it has to be defined on the European Union level, and be creative, but not too much. It's a general remark for all of us, because specifically when it comes to cross-border cases, and now I see it after 3 years here, it's just not enough to say to conflicting parties that certain law has to be applied in this or that way. For them, it's not too much. You need to go more, you need to go beyond, you need to discuss what is the reason of application of one or another law, and then convince the conflicting party maybe to abide by that approach. So that would be from me. Wish you the best conference.